Good morning, I'm Gary DeWaal, and this is Bridging the Week for August 15th to 19th, and today is August 22nd, 2016. Last week, another publicly traded company was sanctioned by the Securities and Exchange Commission for using a standard severance agreement that the agency claimed potentially impeded employees from executing their whistleblower rights. Also, the SEC recently upheld the banning of the president of a broker-dealer from acting in any officer or manager position for 31 days because of his supervisory failures, while a swap dealer was sued by the Commodity Futures Trading Commission in federal court for allegedly recidivist reporting violations. Today's my birthday, so I can get out and celebrate. Let's get started. HealthNet Inc., a former publicly traded company whose securities were registered with the Securities and Exchange Commission until earlier this year, agreed to pay a fine of $340,000 to the SEC to resolve charges that its severance agreements violated the whistleblower protections of ex-employees under applicable law. According to the SEC, from August 12, 2011, when the relevant SEC rules governing whistleblowing became effective, to October 22, 2015, HealthNet required ex-employees receiving voluntary severance payments to enter into a contract under which they were prohibited from accepting a whistleblowing award from the SEC. This restriction, said the SEC, violated its rules that prohibits companies from taking, quote-unquote, any action to impede an employee, quote, from communicating directly with the commission staff about a securities law violation, including enforcing or threatening to enforce a confidentiality agreement with respect to such communications, end of quote. This is the second action the SEC has brought and settled within 2 weeks where firms included in their standard severance agreements language that the commission determined potentially impeded an employee from disclosing to the SEC a possible securities law violation. Time to check out those standard severance agreements. The SEC upheld the determination by the Financial Industry Regulatory Authority to fine Edwin Wedbush, the founder and president of Wedbush Securities, a registered broker-dealer, $50,000 and to suspend him from acting in any principal capacity for 31 days for allegedly failing to supervise certain mandatory regulatory filings. Generally, under SEC and FINRA requirements, principals of a broker-dealer include officers and other management and supervisory personnel involved in the day-to-day management or operation of the firm that are obligated to take a special examination as part of their qualification, typically the Series 24. A president of a broker-dealer is included in a principal category. According to the SEC, from January 2005 through July 2010, while Mr. Wedbush was president, Wedbush Securities filed 158 required reports with FINRA related to judgments and settlements, arbitrations, civil litigations, or regulatory actions, employee terminations, and statistical information on customer complaints late, with inaccurate information, or not at all. During part of this time, Mr. Wedbush also served as the firm's chief compliance officer and business conduct manager. It was the firm's business conduct department that was responsible for the firm's compliance systems and all regulatory filings. In upholding FINRA sanctions against Mr. Wedbush, the SEC noted that because of various FINRA and other regulatory organization reviews of Wedbush Securities, the company was, quote-unquote, put on notice that it was failing to follow regulatory reports as required. However, quote, despite this notice, the firm failed effectively to modify its procedures or the implementation of those procedures to address its numerous regulatory reporting deficiencies, end of quote, said the SEC. Although Mr. Wedbush reminded managers to comply with FINRA requirements, quote, reminding managers of their obligations, even if done repeatedly, was an inadequate response to systemic failures as recurrent and long-standing as those at the firm, end of quote, concluded the SEC. In its decision, the SEC also upheld FINRA's fine of $300,000 against Wedbush Securities for its allegedly problematic filings and supervisory breakdowns. The Commodity Futures Trading Commission filed charges in a federal court against Deutsche Bank AG, a registered swap dealer, for its alleged failure to accurately report information regarding its swap transactions as required by law from April 16, 2016 through the present time. Under applicable CFTC rules, swap dealers are obligated to report timely and accurately certain information regarding their swap transactions to a registered swap data repository, including, quote, messages that constitute real-time publicly reportable swap transactions, end of quote, and certain swap creation and continuation data. Swap dealers are also obligated to correct previously reported data that is incorrect. According to the CFTC, because of a system outage at Deutsche Bank on April 16, the bank did not report any swap data for approximately 5 days and has experienced a number of persisting reporting errors since. Moreover, claimed the CFTC, Deutsche Bank's alleged failures violated the terms of a recent settlement order that followed a prior enforcement action that also alleged swaps reporting problems. In conjunction with the CFTC's enforcement action, the CFTC and Deutsche Bank filed a joint motion seeking the appointment of a monitor to help ensure the bank's ongoing compliance with its swap reporting requirements. In its press release announcing its enforcement action, the CFTC expressly, quote, recognized Deutsche Bank's cooperation, end quote. And finally, two major international regulatory organizations issued a report noting that derivatives clearinghouses have made, quote-unquote, important and meaningful progress in implementing financial markets best practices regarding financial risk management and recovery standards since 2012. However, the same regulatory organizations, the Committee on Payments and Market Infrastructures of the Bank of International Settlements and International Organization of Securities Commissions, reported that CCPs have failed to implement best practices as set forth in the Principles for Financial Markets Infrastructure published in April 2012 in the area of recovery rules and procedures and credit and liquidity risk management. According to the two organizations, the failure of CCPs, quote, to put in place the full set of recovery rules and procedures envisaged by the PFMI is a serious issue of concern that should be addressed with the highest priority, end quote. Similarly, the two organizations noted that the failure of CCPs to implement, quote, sufficient policy and procedures to ensure that they maintain the required level of financial resources on an ongoing basis, end quote, is also a deficiency that should be, quote, addressed with the highest priority, end quote. Well, that's it for this week's edition of Bridging the Week. As always, there is more information in each article and more articles on the article version of Bridging the Week on the website. Check it out. I'm Gary DeWaal. Have a great week, and until next time, ciao.